hardworking man stands before the judge, his freedom hanging by minutes on the clock. Each early departure and late return becomes a silent test of trust and survival. But just when leniency seems possible, a single warning from the bench changes everything.
Judge, at present, Mr. Jones has both a scram device on and a GPS, and he's on a curfew. He's broken curfew a few times, Judge. If you look at the times, though, it's because he's leaving a little early and getting home a little late, the latest maybe being half an hour past curfew. Mr. Jones has maintained gainful employment. He's worked as a helper for a transport company. He's not driving, he's the helper. And so he gets on the truck with the driver, he helps, and then they get back to their site. His wife picks him up from work, and then they pick up their grandkids, and then they get home. He's driving from the east side of town, across the ship channel, down 610 West, and then all the way to 90 into Crosby. It's a long commute. And so due to all that, and his employment is working with him right now. So they typically wouldn't be done at the times they're done, but to keep him on, they're trying to make sure he's done by a certain time so he can make curfew, but it's just a tough commute, especially when he's not the one driving and they have to pick up children because there's only one person that can drive. But he is only late and he only leaves early because of work. That is his only.
You have to understand, you have 2 open DWIs, so it's absolute strict compliance. I never want to ding anyone for working, right? I want you to work because I think that, you need to work. Number one, you need to make money, and it gives you something to do so you don't become more self-destructive as it is. I see the violations here. We have no alcohol violations, correct? Okay, that's good. Joshua Jones. Do we have any alcohol violations?
I have no problems now, Judge. Trust me.
I don't see any previous violations, Judge.
Okay, so it looks like most of the stuff, I would tend to agree with you that, upon further inspection, it looks like it may be a little bit here, but there, but prior to. Is all this work related? Okay, so what time do you leave for work in the morning?
I normally have to be to work at 7,
Okay.
most times.
Because I have here that you leave one time here at 5:56 in the morning. So why that early?
Like I say, most times it's anything that I'm leaving is work related. And one of the things that I've been trying to do since I got out was maybe to get in contact with my lawyer to kind of help me out.
But you're not getting in touch with your lawyer at 5:56 in the morning?
But just because it's a transport company, those jobs have different timelines. They are aware of the circumstances, so they try to tighten up on those timelines. But if they have a job and might need him one day at 6:30 or something like that, that's when he'll have to leave early. And he's afraid he's going to lose that job if he can't comply with what they're asking of him. So I'm asking today, Judge, if we can loosen the timeline a
I'm
little
okay
bit.
with tweaking the schedule.
Okay.
But I want to do it in I'm not going to give you too much leeway. We have to be reasonable about it, right? So I need a time that that's early enough that, you're not going to violate anymore because I don't want to continue to do this, right? So what is a reasonable time in the morning for you to leave?
If he would have asked me to get to work between 6 and 6:30.
How far is it from home to work?
It's maybe a good hour, 10 minutes if it's bad traffic or weather.
What about coming back home? What's a reasonable time?
It's not.
I'm not going to do 9 o'clock. I'm not going to do 9. I don't want you out that late. I will give you a little bit of time after 7 o'clock, but 9 o'clock is too late. When you're coming home here now, you're coming home at the latest at around 7:30. I'm willing to give you, 7:45, 8 o'clock, but that's the latest I'm going to give you.
8 o'clock was fine.
Okay, so Jillian, we'll tweak it 5 in the morning to 8 at night. If there are any more issues, I'm gonna lock you up. I mean, I'm working with you now. There should be no more issues.
Okay.
I want you to work. I just don't want you drinking, and I don't want you out in the middle of the night because nothing good happens out in the middle of the night. And I definitely don't want you driving. Do not drive. I don't care what circumstance comes in your life. Do you understand? I'm really gonna hit the roof if you drive. Okay, all right, Jillian.
Thank you,
You
Judge.
got it. Good morning, Ms. Claus. So it's come to my attention that you have not signed the waiver. So there's 2 options that we have here. You can ask for a bond or you can waive extradition. Once you waive, we give the demanding jurisdiction 14 days to come pick you up. In this case, it's Orange County, Florida. That's where you're wanted out of for grand larceny in the 3rd degree.
For what, sir?
Grand larceny in the 3rd degree.
That means grand larceny,
Larceny is it's a theft.
3rd degree, that's,
As far as, I'm just telling you what they wrote on the actual, on the complaint, it says I'm sorry, not grand larceny, grand theft in the 3rd degree, $5,000. That's what it says. So if you do not want to waive, that is okay. The waiving, it speeds up the process because we only give them 14 days. If they don't come within the 14 days, Harris County releases you. You got to understand, even if we release you, that warrant from Florida will always remain active until you go back to Florida and take care of it. If you refuse to sign the form, that's okay. We will get a governor's warrant, but that takes 90 days. You're going to sit here 90 days waiting for that governor's warrant to hit. So I will let you make the decision with Chablis, what you would like to do. I don't want you to make a decision here in front of everyone. Take your time.
She does want to waive, and they were going to give her the credit for Friday when she was originally booked in. They were going to backdate it to Friday.
Well,
Here's the kicker, though. I just noticed you have an open felony theft case, and you've not made bond on the case. So what happens is that 14 days is typically told until you resolve that case or until you post bond. When all the holds are lifted, at that point, that triggers the 14 days for Florida to come get you. So,
I didn't know you had a case. a
yeah,
local
I mean, I
case.
just noticed it too. So, you can still waive now so that once that hold lifts, it kicks in the
Yes.
14 days. So, well, I'll let you guys talk about it and let me know.
Yes, yes.
Yeah.
Thank you.
All right.
Okay, I'll get the paperwork. to you to sign. It just doesn't come into effect until you handle the paper.
So Chablis, if she waives, there's no need to bring her back out. We'll just sign it and then I can sign it and then we're done.
Yes, yes.
Working on Mr. Jonathan Joyal. It's a young man with 2 cases in your court.
Okay, tell me what's going on.
So here's what's going on, Judge. My understanding, and we're trying to confirm from upstairs in felony, is that he's going to WIMAC based on the new violation in your court of a UCW. So that's causing him to be amended up there and go into WIMAC. That being the case, he's currently in custody. He's only going to be released to WIMAC. So at this point, I'm trying to see what kind of options we have for him. I wanted to come to you to see if he doesn't want to plead to this, how quickly can we give him a trial date if he wants to go forward on these cases?
Alex, do we know 100% that they're going to amend and go to WIMAC?
The only note that I have from the prosecutor in felony is saying that the defense told him the defendant is willing to go into WIMAC, but I don't see any clear indication that that's what they're going to do.
The research I've done,
It happened.
the research I've done on the system and on some of the notes on my end, I don't think they could see it, but it says release to WIMAC only. I looked at the activities up there, and based on all the research, it looks like he's going into WIMAC.
Let me see, maybe I can see something.
I talked to him as well.
Well, I do see on the same day that note was placed, they dismissed the MAJ and just said that there was a condition amended, so it may be that.
It should reflect in the notes somewhere. I can't imagine that one of the
It left
prosecutors is
explanation
gonna.
blank on the motion to dismiss.
Well, no, I get it,
Well-
but don't y'all have like a independent notes to, I mean, every time something happens, you guys should notate what
Yes, Judge,
happened.
and the only note we have that says is defense counsel stated the defendant is willing to go to WIMAC to stay on probation. And then they followed that with a dismissal. So I'm
I
imagining.
see it. No, I see
See
it.
what I'm talking
I
about?
see it says, so like I have here 131 amended conditions of probation, order, release defendant to WIMAC staff only.
That's what I,
Joshua Jones narrowly escapes jail as the judge adjusts his curfew with a stern final threat. Moments later, the courtroom's energy shifts. New defendants bring darker, heavier stories, and one woman's quiet theft charge soon spirals into a debate of trust, love, and betrayal.
that is what, that's mine.
Kelsey,
Yes.
what do you want to do with this case? Because we have these two UCWs. While these are open, we can't do.
One UCW, one evading.
Right, I emailed them, Your Honor, and I mean, I need to have confirmation. that
Have you
he's
put an
back.
offer on this case?
Let me look.
Because maybe you can work something out today. I don't know.
He does, I talked to him. He doesn't want to plead to it.
Oh, but then if they don't want to plead to it and they're not willing to dismiss both, we'll have to set up a
And
trial.
that's why I'm touching base to see how quickly we could go to trial.
You need at least 30 days.
Okay?
So they're going to need at least 30 days to get subpoenas out. So it'll be a minimum of 30.
Okay.
So I guess the ball's in your court.
He's going to be in here. He's going to be waiting on a bed in WIMAC. My understanding is there's a 2-month wait, so we could hit trial before. Yeah.
Oh, okay, so
So we could hit trial before he goes off to
yeah,
work.
what if,
Like a little time to see if Felony can respond and see what's going on and like confirm that.
sure, you want to do like a week to see what they,
Yes, that would be
week or
great.
two? Okay.
Okay.
We'll do a week because I know that you're itching to get
The
the,
only thing is I lose a week, right? I lose a week. If we're going off to 30 days, I'm losing a week just by doing this. All
no,
Okay.
for that day. And
right, let me talk to my client and see what's going on. Okay, thank you.
sure.
Thank you.
Do you want to talk about something else real quick?
I had one other one, and here's the,
Okay, great.
since she signed the waiver, we're gonna set her bond at 1,500 for the silence.
We're setting the bond at 1,500, right? For,
Gonzalez. Cause she came and gave this to me after she signed, but she didn't reapproach with you.
yeah, she didn't say definitively whether, yeah, of course I wrote it on the docket and I'm assuming that because she filed that we're going to set the bond at 1,500.
What is it, a withdrawal?
Yeah.
Yeah, it's a
Oh,
waiver.
yes.
Yeah,
If they're-
okay. On Patterson,
Yes,
540.
Alisha Patterson.
Alisha Patterson, yeah. This was on last,
8810.
it's set for April 3rd.
Yep, so I just noticed, I didn't get a chance, you ought to have read the probable cause before I got in here, Judge. But I noticed that, I don't think it meets the probable cause. I was gonna see if we could read it.
Yeah, absolutely. So you want to do a probable cause hearing?
Yes, we can.
Okay, absolutely. Please.
All right.
Did you get it? The cause number?
Yes, I was at criminal trespass, is that the one we're on?
Yes.
January 24th, 2025, Leo dispatched to apartment regarding family disturbance. Law enforcement officer made contact with complaining witness. Complaining witness and former dating relationship with defendant. Stated defendant has been banging on door of her apartment since 1/23/25.
Yeah.
Defendant did not make any threats or say anything besides banging on the front door. Law enforcement officer observed defendant moving around rear seats of complainant's motor vehicle. Complaining witness approached her motor vehicle, claimed ownership, and ID'd defendant as person inside. Complaining witness stated she had recently got a motor vehicle, had not let defendant borrow a motor vehicle or use it in any manner, and also stated that she secured all the seats. Defendant stated motor vehicle was already unlocked and law enforcement officer did not observe signs of forced entry.
So just for trespass, you gotta either have been warned before, don't come around here, I don't want you here, or you're there and then you're told leave and you don't leave. So this doesn't fit either one of those. I mean, the door's already unlocked in the car. She's never been told not to go in this car, stay there. In fact, this is the lady that the complaint witness was here.
I remember that she was here.
They stayed.
I,
They have a bit of a history together as well. I think there was a prior where the complaining witness.
so the trespass is with regards to the car,
Yes.
okay? Did the complaining witness tell her to leave and she continued to stay? Or was there some kind of notice prior that, hey, you know, I don't want you here, or, go through it one more time, will
She
you?
did not let her borrow it or use it in any manner.
She just took the car?
She was just in the car.
She was just in the car?
It was cold that night and she was trying to get in and, I know this isn't here, but the complaint witness told me that she didn't hear the initial call, initial knocks on the door. It was later when she reviewed the Ring camera that she saw her at the door since then, but she heard at the last few, the knocks or whatever. And that's when she viewed the camera and then called the police. But I think it was more of a situation that she wasn't sure about her mental state. I know this isn't here either, but that's what she told me.
Right, but we can't get into the facts that are out because that's not fair to them, right? What
She
we,
shared with one of the prosecutors, he's not here today. I forget the young man's name. And talked to Shisley with him.
oh, with Alex,
Yeah. He did speak with her, absolutely.
so did she tell her to get out of the car?
Well, she didn't let her in her house, which,
Right, but she's charged with the trespass of the car, right? So did she, at what point?
no, but she did go out of her way to say that she has never let her use the car, never borrowed it, let her borrow it in any manner.
So she's just in the car when the cops roll up?
This fact, yes. That's what I understand, having not spoken to the complaining witness myself.
How did she know that she's not supposed to be there? Because from what I understand, they're in a relationship.
Prior dating relationship.
How much former?
Not sure of that, Your Honor.
Is it something where you broke up 6 months ago and you know you're not supposed to be in the car, you know? Or is it something where it's,
There was a previous charge against the
I mean, let's look at the statute. Hold on.
defendant for stabbing the complaining witness. So
Say it again.
there's a previous charge against the defendant for assaulting the complaining witness. So I would imagine that there's not supposed to be.
Remember, we don't work on hunches, right? It's got to be
Yes, true.
definitive. Texas Penal Code, criminal.
It's 30.05, I guess.
A person commits an offense if the person enters or remains on or in property of another, including residential land, agricultural tract, recreational vehicle, park, a building, had noticed that entry was forbidden or received notice to depart but failed to do so. Did she have noticed that entry was forbidden?
Doesn't appear so, Your Honor. They had been broken up for a couple of weeks at this point. I do.
But Harold, you know, if you're broken up, you know or should know that you're not supposed to be there, right? I can't just go to someone's car, enter the car. I know it's cold, but that doesn't give me the authority to just go in someone's car and sit in it, right?
Well, it was cold outside.
I don't
She knew it
care.
was her
Even
car.
if it's 100 degrees, you can't just go into someone's car, you know, and just stay there as justification for criminal trespass. You know,
Well, but I mean, we're also justifying the state filing these charges, Judge, by them not having the complete amount of the facts and here the complete, the elements. You know, as far as, just like you read, like I said at the beginning too, the no notice entry was forbidden or
well, no,
receiving notice.
but if you're broken up with someone and you're no longer in a relationship, you can't just go into that person's car and assume that you have authority to go there, even if it's 2000 degrees below Fahrenheit or Kelvin, right? That it just doesn't jive. It doesn't make sense. I don't think that would be a reasonable interpretation, you know? If they were in a relationship, in a current relationship, then I think that would be reasonable. I think that would be okay where you could go into there, but if they're not in a relationship anymore, I think that would be, I don't think that would be reasonable, you know? If you show me something different, then, and I'm all with it, right? But you know, or you should know at that point, you can't just go into someone's car.
I understand, but I did check the report too, and the report mirrors this exactly. So they've got no other evidence, so they might even.
Well, Judge, she hadn't moved out, so she had taken her stuff and moved off the premises.
She had moved on.
She had moved out over a month ago.
Right, so that's what I'm saying. That adds credence to that. You can't just go into someone's car. I know it's cold. There are other places that you can go. And I don't think that that's a reasonable justification
Yeah, the month.
to violate.
I understand. The month, facts are coming from the report. And in that report, she does tell the officers, I still have stuff in there. I live here. You know, my client says that, but we might be able to work this out. I understand.
Right, but nevertheless, they had broken up. She moves her stuff out, and she may be saying that to the cops, right? To be able to not get arrested, right? But what we have here is that they're no longer in a relationship. She's moved on. And yeah, I think that there's enough, you know? Sorry, Harold.
Thank you.
Okay, close.
It begins with Joshua Jones, a man walking the razor's edge between discipline and desperation. The courtroom hums with quiet tension as his defense explains Jones wears a scram device, a GPS monitor, and lives under curfew. Yet his violations, each departure too early, each return too late, are born not from rebellion, but from a grueling job and family obligations. He isn't drinking. He isn't breaking the law. He's simply racing against time, traffic, and circumstance. The judge listens, torn between empathy and authority. And her tone lies a careful balance, stern but human. "I never want to ding anyone for working," she admits, but her eyes narrow as she reminds him of his 2 open DWIs. Each word presses down like a gavel stroke of warning. She quizzes him about his schedule, his commute, his purpose at dawn. Jones pleads his case with quiet dignity. Every early departure, every late arrival, all for work. After a tense exchange, the judge yields, a small mercy in a room built on order. She extends his curfew, 5 a.m. to 8 p.m., but her voice hardens with the final edge. "If there are any more issues, I'm going to lock you up." The moment freezes. The weight of that sentence is heavier than the ankle monitor he wears. Jones nods, humbled, his freedom spared, for now. Then the rhythm shifts. The next case introduces Miss Claus, wanted for grand larceny out of Florida. Confused and weary, she faces a grim choice: waive extradition and risk being taken, or wait months behind bars. The judge explains the bureaucratic trap she's in. Freedom is possible, but so is endless waiting. Justice here is a maze with no map. But the day's true turning point comes with Alisha Patterson, a woman accused of criminal trespass against an ex-lover. The details unfold like a slow-burning drama: a breakup, a cold night, a locked car, and a desperate need for warmth. The judge reads the report aloud, dissecting every word. There was no forced entry, no threats, just Patterson sitting in her former partner's car. The defense argues it's not trespassing. There was no warning, no notice, no defiance. Yet the judge pushes back. If you're broken up, you know, or should know, you can't just go into someone's car. The logic is simple, brutal, and unwavering. What was once a shared life has become forbidden ground. Even love, once lost, cannot be a legal defense. The courtroom falls silent as the judge concludes. Her tone is not cruel, but resolute. For every plea, every excuse, there is a line, one that must not be crossed. From Jones's tightrope of responsibility to Patterson's moment of misplaced longing, the theme is the same. Freedom isn't given, it's guarded. As the session ends, the echo of justice lingers, a reminder that mercy and punishment often wear the same face, depending on which side of the bench you stand.